righty. The matter of Jannereth versus Jannereth, case number 01-04328DO. Now that I've delved back into some old property law stuff, Miss Jannereth, I think at one point during one of the motions you said you filed a quitclaim deed a long time ago.
He filed a quitclaim deed because
No,
Terry was going to
I
quit.
thought, no, you filed one, correct? I thought you said you filed one granting your interest to him.
No, never. No.
Okay. All right. That's because, yes, there is a quitclaim deed indicating that the land is back in Larry's name.
Right.
However, the judgment of divorce has have given both of you equal ownership of that property until sold.
Right.
Okay, so you still own half of it.
Right.
So I can't make her, though, sign a HELOC or anything on that house, Miss Curlis. She's not going to incur debt because he's living there.
Okay.
So that I cannot do. The question is, how do we do this? Because there are a couple problems here. One is we are well over the 10-year limit that the court can enforce orders like this. This judgment died in 2013.
May I
So,
ask a question?
Sure.
Does this mean that he cannot take me back to court again?
No, it does not. You both own this house.
Okay, well,
that's where the court was mistaken before, is because in looking at property law, the judgment gave you both this house as tenants in common.
right.
Meaning that, ma'am, if you die, you can have your half of the house inherited by anybody. If he dies, he can have his half of the house inherited by anybody, and then you own it with the person that inherits it. So you
Right.
own each of it. When you're married, the property is owned by what's called the entireties, which means if one of you die, the property automatically reverts to the other person completely and wholly. That's not what happened with your judgment. Your judgment gives each of you half. You still have half ownership on this house.
Does that mean that I have a say in whether or not the house gets sold?
It could be, and that's what I'm getting to next. I'm not sure
Okay,
what
thank
to
you.
do here because technically you have a partition action in district court, Ms. Curlis, more than you have an
Okay.
action in circuit court. But
Your Honor, can I make it clear that the $50,000 HELOC, Ms. Jennereth would not be taking on that debt. The bank is just saying that because she is on the title, they would need her permission.
permission,
him.
okay.
Permission to take, so she's not co-signing on that debt
Right.
at all.
In other
So
words, she would have no, but
she's
it would be attached to the house.
that is correct. That is correct, which a part of it,
Yeah.
obviously, as I mentioned, would be used for paying off some of his personal debt when he had to get his truck
Right.
fixed.
That's why I'm not, there's no way in heck I'm going to have her sign. Now, if she signs the permission for him to do that, Ms. Jennereth, I would suggest you might want to do that. The problem is there's a history here of him not paying mortgages and payments. So I can understand why Ms. Jennereth, the problem, Ms. Jennereth, is if a lot of these repairs need to be done, it enhances the value of the house so that if you ever do get it sold, you know.
I understand that, but he's lived in that house for 11 years now. Those repairs didn't just happen overnight. They should have been repaired while he was still working and making money.
And at this point in time, that's not relevant. What's relevant is whether those repairs need to happen or not to maintain the house. You don't want that house getting dilapidated and being unsellable and unlivable.
Well, according to him, it's already that way.
I understand. That's why he's coming to court to say, I need to get this HELOC.
Okay, then let's say that he gets that loan and the house sells, then I lose out on profit of that house because he owes so much more on the house.
Well, what should happen is that 50,000 should come out of his portion, not yours.
Okay, but I don't know if you realize it or not, but that house should have been paid for 3 years ago, and he still owes $54,000.
There are many things that should have been paid off years ago and did not get paid off. So You know, bottom line, you guys set this up and now you've tied yourselves together forever instead of undoing it in 2001 like you should have. Now,
Right.
I admit that there were some underlying issues and people were trying to be kind. Unfortunately, in family law, the rule of thumb is no good deed goes unpunished. So I can't force her to sign something like that, Miss Curlis, because I don't believe I have the authority to it, especially at this point, long after the judgment's enforcement capacity on property is done. I can only enforce quadros at this point because they're ongoing and they don't come due until now.
Correct. Okay.
I would suggest, Ms. Jenrith, that you look carefully at that and maybe go ahead and sign the ability for him to do it on his time. And Ms. Curlis, I would offer an order that says any loan that HELOC that he takes out is from his portion of the proceeds. Because he's
Okay.
the one who's been living there, he's the one who's been letting it go. And maybe they would have been cheaper had he have done it 8 or 9 years ago. That is part of the argument, but not the argument. The argument at this point is how do we maintain the house without it going and getting trashed completely.
Okay.
So, what I will do is I will reserve the right, if you need a settlement conference to discuss this further, Ms. Curlis, you may call the court. You may call Rebecca and I'll set that up so that we all may meet and see what we can do, because we got to untangle this mess somehow. Because right now, both of them own it, which
Right.
means and that's where the court got confused last time, because the only thing presented to the court was what you presented, Ms. Curlis, which is the quitclaim deeds. And it shows that he is owning the whole as a single person.
Sure.
But what nobody has tied in the past is that the ownership that his ownership and his sole ownership is only half.
Correct.
And there's where the court lost a misstep, because they read the quitclaim deed as being the whole, and it is not. This Jenrith still has half interest in that house.
Correct.
So unless and until she signs off on it completely, and that would be a partition request through district court, because I don't think I have the authority after this many years after the judgment's been entered to do that. Now, the district court may kick you back and say, no, it's got to be in circuit court.
Yeah.
So I know it's back and forth because we're getting very technical in which part of this, who gets to do and what part is still necessary. I think the last time I tried to get Miss Jenrith out of this completely, because it was my understanding that she had signed a quitclaim deed and that he owned the house lock, stock, and barrel, and he does not. So they are still tied together as tenants in common. Ms. Jenrith, you might want to consider, like I said, signing that, but making sure that you sign paperwork that allows him to do this, but exonerates you from any responsibility on the debt.
I would rather the house be sold as is, just to get out from underneath it. I'm tired of it.
That's got to be a court case, and that's something that you guys can discuss as well. That
Okay.
might be the only way to do this. Either that or figure out how to take on more of a equity loan, figure out how much the house is worth, and pay her off her half.
That's what I would prefer.
And that's something that you guys can enter into discussions on. Because I'd like to untangle you guys as best as possible, but I'm not sure of your monetary situations, how much the house is worth, what is fully owed on the house. I don't have any of that information. So, but that's something to consider and maybe what you do is, Ms. Curlis, you sell it and maybe on the open market, he buys it out completely. I mean, but that would entail and that would help her. That would help Deanne get off the case, and then Larry, he can move on with his life without a cloud on that title.
Okay.
Thanks for making me go back to law school and real property classes.
Not a problem.
It took a little bit of research, and then it took some thought to figure out, because there's some moving pieces here that just do not connect.
Sure.
You have to actually read old documents and figure out how this flowed. And I finally did.
Okay. I think I will talk to Mr. Jenrith, maybe reach out to his loan person to see what options we have, and then present them to Mrs. Jenrith to see what she is willing to do.
I am not willing to sign a loan at any time. Never.
I'm not. Nobody is, Deanne. No one's asking you to sign a loan.
I know. I'm just letting her know that I am not going to do that. I want the house sold as is. I want out from underneath it. I can't handle the stress. I have an LVAD. I'm on the heart transplant list. I need to get out of this. I'm sick of the
Okay.
harassment. I'm sick of the threats.
That's, well, like I said, you guys tied yourselves together and I can't untie you. All right. So, Ms. Curlis, I'll reserve that right for a settlement conference if necessary, and we'll see. And maybe if we have to have a hearing eventually on whether we sell the house or do it, but I'm not sure that this court has jurisdiction. I think it's district now.
Okay,
All
all
right.
right, I
Okay.
appreciate that. Thank you, Your Honor.
Yeah, look at the statutes about the 10-year statute of limitations on judgments.
Yep,
Because what has to happen is you have to renew that statute. And there is case law out there that says the 10-year statute of limitations on this stuff applies to divorce judgments as well.
okay, all right, I appreciate that.
Unless they changed it, because the last time I looked at it was 2 years ago, and that's
Okay.
what the status was then. So, but you know how they like to change things. So Lord only
Yeah.
knows. All righty. Good luck, everybody.
Okay. Thank you.
Thank you very much.
Thank you. But denied at this time without prejudice. Yeah. Okay. That's messy. It took me a while to figure that out. I was like, why are they still, and then you have to read the judgment, then you have to actually really look at the quitclaim deeds
Yeah.
and realize, because they don't say that it's only half an interest. They just talk about his interest and her interest, and there is no talk of her interest. So when Judge Zamitis saw it, he assumed what I would have assumed on the face of that quitclaim deed, that Mr. Genereth is the sole owner, and he is not.
Mm-hmm.
He can only own half. So that's all he can actually transfer to somebody is half. He can never transfer more than he has. All right, next.